For larger trusts, the choice of a trustee is very important. And typically, you want someone with some experience in handling a special needs trust. We create trusts all the time for persons without disabilities who, where we have family members, trusted family members as trustee. For special needs trusts, especially if you're talking about lots of money, you want to at least consider a corporate trustee who has experience in handling special needs trusts. Oftentimes, especially for third-party funded trusts, a family member is okay because you're less likely to run afoul of any regulations if it's a third-party funded trust. Don't forget, there's no payback in a third-party funded trust. If parents or grandparents are funding it, there's no payback to the state. So the state doesn't care as much about those trusts, and they don't scrutinize things as carefully. But if it's a self-funded trust where they have a payback, they're going to be looking at what those monies are being spent on. They're going to be looking at whether that trust fulfills all the requirements of the federal law, because they want any money that's left at the end of the rainbow. So for self-funded special needs trusts, you really want to at least consider a corporate fiduciary, somebody who deals with this all the time and knows what to spend money on, what not to spend money on. Which corporate trustee is best? Fees, customer service history. Ask somebody who deals with trustees all the time. We can generally, privately, tell you who we've had a good track record with and who we haven't. And other people who do this work, I think, will privately do the same. The demands on a trustee can be significant. You get an individual who may be disabled, a disabled beneficiary, who is cognitively there but is physically disabled, or is bright and intelligent but has mental health problems. They may be making demands upon the trustee that have no basis in law, and the trustee has to tell them no, 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 no. And sometimes the family wants to use this special needs trust that perhaps was from a personal injury settlement, from a birth injury, or from a car accident, and the family, who oftentimes is providing a lot of care, wants to use it as their own source of income. And that can be very difficult for a trustee to manage. And we frequently have to advise trustees where inappropriate demands are being made by the beneficiary or by family members. But there are circumstances where the courts will consider, where they see a family that is losing income because perhaps one or both of the family members has had to quit a job to take care of the disabled person. And even in self-funded trusts, the court will sometimes consider paying family members to care for the disabled person in recognition of their own loss of income. But the court will scrutinize that carefully. All right. Well, we have come to the end of our special needs trust part of the program. And at this point, I'm going to turn it over to Drew Coates, who I've worked with for many years. Drew has been in charge of the Special Needs Trust issues with the Department of Public Welfare for some time, and I've spoken on the phone and presented with him hundreds of times, and he's really historically done a wonderful job for the Department of Public Welfare and been someone who you can talk to. Not everyone in a government agency is someone who you can talk with, can reason with, and who will look at things objectively. And over the years, I really think that people who do the work that I do have been fortunate to have someone like Drew who knows what he's doing, listens, and cares about the people that we all serve. And Drew's going to talk about a number of elder law issues about the kinds of things that can be done for people over 65 and in planning for disability in those circumstances. So, Drew? What's that? Okay. Okay, and we can take some special needs trust questions now, or we can wait. But why don't I take a few now? Is that okay, Drew? We'll take a few now, and then I just want to make sure we leave enough time so that people can hear what they have to say. Yes, sir.
Is there there an age at which the recipient of that trust might break so that the laws would change? If something happened when they're 18, or anything of that kind as far as the state will support or anything like that?
Now, I'll repeat the question so I make sure I understand it. Is there an age at which the special needs trust would lose utility and couldn't be used for disabled persons?
No, I don't mean that. I'm sorry. Is there an age at which the state support for that individual might change that would affect the trust?
Okay. Is there an age at which state support for the individual would change that would affect the benefit of the trust? And the answer to that is no. I mean, you can qualify for SSI and for medical assistance as long as you live. Now, for many people, if not most people, SSI will become Social Security when you become Social Security retirement age. Many people go from SSI to a Social Security check, but not everyone does. And medical assistance can cover you until you die. Even if you get Medicare at a later time in life, if you meet the financial qualifications, you'll also qualify for medical assistance. And medical assistance, as I just said, will pick up a number of things that Medicare won't. So even if you're getting Social Security and Medicare later years, so long as your income and resource qualifications allow you to get medical assistance, you can continue to get it until the day you die.